before you begin, please could we just say, at least up here, we feel it's very, very cold in here. I don't know how you feel down there.
Yep.
And I've turned the dial, the wonderful, you wait so long to be in control of the dial. And then you discover it doesn't work. So I've got it turned right up, but no love or reaction. So if it were possible, Julie, to see what could be done, we'd be very grateful.
Yeah.
Otherwise, we'll all be shivering in our boots. Thank you very much, Mr. Prosser.
Yes. So I'm now going to make some very brief submissions as to the nature of GSAM's decision-making power. My submission is that it had an unfettered discretion. And I'm making points about the terms of the LLP deed. First of all, we see the first subparagraph of 11.9c says any member may, in his sole and absolute discretion, decide that special capital should be reallocated to any other member. That reference I submit to absolute discretion. The ordinary meaning of that is that it's not trammelled, it's an untrammeled discretion, unfettered discretion, and that makes sense in the context of any member. Why should one imply a term, a Braganza type term, into that first subparagraph to suggest that every member has an obligation as to how they deal with their own special capital? Then if one goes to the second subparagraph, we've seen the last sentence there, for the avoidance of doubt, the retention member, that's GSAM, shall be under no obligation to follow the recommendations of the managing member and shall have absolute discretion as to how it applies any profit allocations it receives from the partnership. Now, the reason it says for the avoidance of doubt, I would submit, is because we've already seen, insofar as it having an absolute discretion, is we've already seen that in the first subparagraph what the position is as regards any member. GSAM is an instance of a member. So it's saying, well, we've already dealt with this. We've told you already that any member has an absolute discretion. If it's right that you wouldn't imply a Braganza type obligation in the first subparagraph, my submission is this sentence, for the avoidance of doubt, is saying GSAM is in the same position as any other member. The next point is, if one contrasts these references to GSAM having an absolute discretion with other clauses of the LLP deed, 11.9b, back on page 20, says the corporate member, that's GSACS, may determine in its discretion acting in good faith. So there we have an express requirement. Okay, you've got a discretion, but you have to exercise it in good faith. Now, that is, I would submit, a clear indication that when the drafter wants to say that the discretion is trammelled, it doesn't call it an absolute discretion, it calls it a discretion, but says you must act in good faith. The contrast is with GSAM's absolute discretion. Likewise, if I can take you to back on page 16, clause 10.3, C. This is now referring to the managing member, that's Mr. Gerko. There shall be allocated to the retention account of the corporate member such amount of profits as shall, in the opinion of the managing member, acting in good faith. So again, when the drafter wants to say you must exercise your judgment by acting in good faith, the drafter says so. There's a similar contrast in clauses 11.4 and 5 on page 18, both of which talk about the discretion of the managing member, that's Mr. Gerko. 11.4, the third line from the bottom, at the discretion of the managing member. And then 11.5, the managing member shall have the discretion. Again, not an absolute discretion. So perhaps it's a constrained discretion, but anyway, it's a contrast, a clear contrast with an absolute discretion. And then if one goes to clause 14.8 on page 27, 14.8, the bottom of page 27, talks about the position of the managing member, Mr. Gerko. He shan't be liable to the partnership or any other members, except by reason of acts or omissions due to bad faith, recklessness, negligence, and so on, or for not having acted in good faith in the reasonable belief their actions were in, not opposed to, the best interests of the partnership. So, we're told that the managing member, Mr. Gerko, his liability is limited, but not to the extent of him being able to act in bad faith. So that ties in, I would submit, with the references in relation to him having a discretion, but not an absolute discretion. There is no equivalent of 14.8 for GSAM. There is no limitation on its liability, with an exception. Cutting it down, you've got to act in good faith, and that makes complete sense because it has an absolute discretion. There are no circumstances in which it can be liable in my submission.
Doesn't GSAM act through Mr. Gerko?
No, it doesn't. No, it is
Who makes the
acts on his recommendations.
Yeah.
But it's not. It's expressly said that it doesn't have to follow his recommendations, and it has an absolute discretion as to what it does with its special capital. And then, just a couple more points. Clause 25.1 on page 45. Is an entire agreement clause. This deed constitutes the entire agreement between the members, and there are no other written or verbal agreements or representations with respect to the subject matter hereof. And then 25.3 at the bottom of page 45. Each of the members acknowledges and agrees he has not entered into this deed in reliance upon any representation, warranty or undertaking of any other member or of the partnership which is not expressly set out or referred to in this deed. Now, my submission is that the drafter of this LLP could not have made it clearer that you've got to read the provisions at face value. When it says absolute discretion, it means what it says. That you can't imply that that discretion is subject to requirements of good faith and so on, because what more could the drafter have said? This is the entire agreement. There are no other agreements. There's no other undertaking of any kind. In other words, there's no undertaking that I will exercise my absolute discretion in good faith. And the final point to make is that doesn't give rise to a possibility of an odd result in the sense that GSAM could run off with the money, as it were, because, as I've already mentioned, we have this purpose trust of its shares. And then just for completeness, the Upper Tribunal discusses those provisions of the LLP deed at paragraphs 53 to 90 of its decision, starting on page 162. And my submission is that it erred in its interpretation of the deed. So, for those reasons, my submission is that GSAM not only had no obligation when it took its decision, but it had no obligations concerning the taking of the decision. There was no Braganza-type obligations. So that if one says that a legal right is necessary for a source, there wasn't one. If one says, well, no, that's not a requirement, instead it's sufficient that there's a decision which is subject to a Braganza, it's fettered in a Braganza-type way, again, my submission is there wasn't such a discretion in this case. So those are my submissions on the source, miscellaneous income.
Thank you very much indeed. Mr. Chacko.
Thank you, Melody. Subject to any questions, I was going to organise my submissions as follows. Am I speaking loudly enough?
A little louder, please.
Great.
Thank you.
So I was intending to organise my submissions as follows. First, to remind you of the basic arrangements here and how they work, and take you to a few of the documents, particularly in light of what Mr. Prosser is arguing in terms of how clause 11.9 works. I think that's very, very important. Second, to take you to the Braganza issue and that line of authority, and then to move on to source, which I'll deal with in three parts. First, the cases that deal with whether a payment is voluntary. Second, this question as to whether or not you need to possess the source. And third, whether an activity can be a source. And so that will be my case on section 687. Describing the arrangements, I'd like to start with the explanation that's given by the Upper Tribunal in paragraph 1. So the Upper Tribunal's decision is in the core. At tab 11. So page 152.
Mm-hmm.
And if I'd ask you to read paragraph 1, and then paragraphs 8 to 10.
Yes.
And noting in particular the phrase that they introduced with that this is a deferred remuneration arrangement. I believe Mr. Prosser described it as a remuneration deferral mechanism. So that is what this is basically doing, is I think common ground. 12 to 14 flag up the relationship of this case to Bluecrest. As it says, those are similar arrangements. I will be submitting that they're in fact materially identical arrangements in every important sense for this hearing. But to flesh out the description in 10, I'd like to take you to some of the core documents. The LLP deed is in the documentary bundle at tab 1. And if you go to paragraph 10.3, which is on page 15,
Was 10.1?
10.3.
3, yep.
Page 15. Clause 10 is dealing with how they allocate profits. And 10.3 sets out how they're to be allocated. And the retention member here is GSAM. And so what you'll see from clause 10.3, which sets out how the profits are to be divided, is that GSAM is able to have an allocation under subclause B if it has income arising on its special capital, but otherwise its only entitlement is under D. It isn't an individual member, and so it wouldn't be eligible under, for example, E. The pre-retention amount is defined on page 10 of the bundle.
Yes.
And I've taken this quite quickly because you may have read Bluecrest before, because otherwise this could be slightly confusing. But what is going on here is that there is a notional sum which might have been allocated as a profit share to an individual, and that is being deferred. And the way it's being deferred is that a fraction of that is going to GSAM, who, subject to the meeting of conditions and the exercise of their discretion, will pay that out in later years. And the way they pay that out is to reallocate the contribution and reallocation of special capital. That is the same basic approach as basic arrangement is in Bluecrest, and also for that matter in OD, which was only heard at first instance. But you'll see that in this case, unlike in Bluecrest, the definition of the pre-retention amount shows that you actually calculate how much is notionally going to each individual, and then you divide it up.
Yeah, there wasn't that particular calculation in Bluecrest.
No, in Bluecrest it wasn't done with this level of formality, or embedded in the deed in this way. And so, if this case had been heard before Bluecrest, I would be arguing that the true division of profits among the members would be that each individual gets essentially their pre-retention amount. They get both their immediate allocation and their deferred allocation. And this matters because for taxation of partnerships, in the year in which the partnership earns its profits, you calculate the profits for the whole of the partnership, and then you allocate that to the members according to how they've agreed to share in the profits. And so, in Bluecrest, Crown were arguing this case in two ways. First, that when you set up this sort of deferral mechanism, each individual is taxed on their whole amount, both what they're allocated that year and what they're promised in later years. Or alternatively, they're taxed on the amount they're allocated in that year, but also on what comes out of the deferral mechanism when it comes out.
And that may be, obviously, therefore, it came out, although it was from a previous year, it comes out later. And you're taxed there on that year, on what you actually receive and what you receive which has been deferred until that year.
Yes, in that later year you'll have a profit share if you're still a partner, and you'll also have your receipts under a miscellaneous income.
You're discussing the 850 argument at the moment,
yes.
and we're not.
Yes, but it would mean that in later years you would have both. You might well have both a profit share for, say, 2013 and some of the deferred remuneration from earlier years coming out of miscellaneous income.
Okay. Well.
I think that was the question you were asking.
Yes, and I think that's the answer you gave.
Yes. But obviously we're bound by Bluecrest, and so the Crown isn't arguing that 850 argument here. We're arguing that we're the same as Bluecrest, and that there is a tax charge when the money comes out, essentially. Now, special capital is dealt with in clause 11.9, and you have read it, so I'm going to be looking at it in some care, but I won't ask you to read the whole of it again if you have just read it. I would point out, however, D, which I think Mr. Cross said that you didn't need to bother with at that stage. But I think that D is quite important. D is the provision that allows the individual members to take special capital out. That's how they end up getting something from the deferral arrangements. And I would say, there's been a lot of argument about how none of these reallocations create any rights. And there's that D looks quite like a right to me. That if you are an individual member...
There you go, Mr. Chaco. Game over. Sorry.
Well, do you rely on D, or I mean, what happens on the actual reallocation?
Well, Yes.
Going back a stage, I mean, D is the time you draw it out, which can be 14 days after the reallocation. But the reallocation itself,
I would absolutely say it confers rights.
because aren't there other provisions of the deed that basically say that whoever it's allocated to, the special capital is essentially the assets represent the property of the partner.
Yes, they're treated as beneficially theirs, and that's how they can, like, income arising on those assets is treated is allocated to them.
Yeah.
And so on.
Well, as a thing was pointed out in Bluecrest, the language is actually quite odd, and there was discussion about whether the assets were partnership assets at all in Bluecrest. But as I understand it, once the capital is reallocated, and it's top of page 20, I don't know whether this only whether that provision is only relevant to the person contributing the special capital, or whether it's relevant to the person to whom it is reallocated.
I would understand it as applying to the person to whom it's reallocated as well.
Yeah.
I mean, that's the basis.
But it is possibly important because it's a real. The concept of special capital is these assets are really high, identified as belonging to the relevant party.
Yes, and I think that's how this is supposed to work. They shall be held exclusively for the benefit of the relevant member.
I mean, that sentence starting at the top of page 20 is certainly not restricted expressly, is it, to the person putting that amount in?
Well, I would say that the whole concept of being able to reallocate it suggests that it can change from being held for the member and contributed it to the member who, to whom it is reallocated. I mean, and the same is actually said in C, in the middle of the first paragraph. Such other member or members will, following such reallocation, become beneficially entitled.
Oh, sorry, that's even clearer. Yes. Thank you.
Yeah, in the middle of C.
Yeah.
But in terms of then how that works, so I'll go into. I was going to take you through how it's applied to Schedule 6, and then look specifically at this question as to whether or not there is really this distinction Mr. Prosser is drawing between the decision to reallocate and the reallocation, which I think is not actually a distinction that the clause provides for. But you've seen that Schedule 6 and 7 are referred to in 11.9. And what I draw from that is that these forms of recommendation, which are sent to GSAM or which are sent to individuals telling them what GSAM is likely to do, are part of the partnership agreement. This is in no sense a private or separate set of actions taken by GSAM. This is part of how the LLP functions, and it's agreed by GSAM, which is an LLP member. So the forms, you'd be taken to Schedule 6 and 7, so I don't know if I need to ask you to read them again.
No, if you just draw your conclusions from them for us.
Well, that's my conclusions from them, that this is the structure of this is embedded within the deed. It's not separate from the set of contractual rights members have against each other. And then you see this working in the way the letters are then written. Mm-hmm. So at tab 3, page 63, you see a letter to Mr. Shakin, which I think is in the agreed Schedule 7 form, which is in the agreed Schedule 7 form. Mm-hmm. It tells him that he has a potential award. It doesn't, and it gives the conditions. It doesn't tell him exactly what that will be. It tells him the value band that it will be in. You then see at tab 4.
So when you say it tells you the value band, oh, it's just that band A to E?
Yes.
Okay, I'm with you.
So that's another difference from Blue Crest.
Yes.
Then at tab 4, you see the letter that goes to Mr. Bruder, who's the director of GSAM, making recommendations. And that's in the Schedule 6 form. At tab 5, you have the resolution of GSAM, which considers the letter it's just received, and agrees. This is on at clause 3.1 that they will follow the recommendations and consider them again if there are new recommendations.
And it's 3.1 should follow the recommendations, and 3.1.3 take the steps.
Yes. But at that stage, they don't, I think, take steps. One of the differences again between here and Blue Crest is in Blue Crest, the corporate effective retention member would contribute special capital immediately, and the money would wait within the special capital. In this case, they invest. Well, they do take the step of making investments as recommended, but they don't actually contribute to the special capital until shortly before it's to be reallocated.
Yes.
And you see that then at tab 6, which is a year later, there is another letter to Mr. Bruder referring to the earlier set of recommendations. And one of the things it recommends is you perform the redemption of the first tranche. That's 2B, and at 2C, they recommend you contribute the proceeds of special capital. And then if you turn over the page, they then recommend let you wait for a month, which you have to do under 11.9C, and then reallocate. I mean, they don't, for example, make any reference to you should wait for a month and then decide to reallocate. This isn't treated in this correspondence as if it's a separate step. Then at tab 7, you have GSAM making resolutions in light of that. You've got to bear in mind that there are actually, even though we've only seen one resolution, there are actually 3 different things it's doing. It's selling its investments, it's contributing special capital, and then 1 month later, it's reallocating. And there don't seem to be documents. We haven't seen documents that divide those up.
Okay, so you think this resolution covers all of those steps?
It's the only resolution I think we're aware of. Yeah. Yeah. I mean, this is obviously before the month has even started, because you can't reallocate until a month has elapsed after you've contributed special capital. So what we don't know is at what stage after this they then sell their investments, contribute special capital, and time starts running to allow the reallocation. What we do know, if you then turn over, to tab 8 is that Mr. Shakin is informed of his award about 3 months later. And what he's informed of is that the company has decided to reallocate amounts to a special capital. Notifies him that he now has the right to withdraw.
So, by being notified he has a right to withdraw must mean the reallocation has happened.
Yes, it's clearly happened by this point. So, the appellants argue, going back to 11.9c, which is page 21 of this bundle, that there are no legal consequences to deciding to reallocate. I think that's the phrase that was used. Because what matters is reallocation. There isn't, I think, anything in 11.9 that deals with a distinction between reallocation and deciding to reallocate. There's nothing that says the reallocation shall take place 3 weeks after decision or something like that. And this is a document, an agreement that has to be construed in a realistic and commercial way. I don't think that they are suggesting there's any material difference between the retention member deciding to reallocate something and it being reallocated, because they would have made provision for that if so. It's not entirely clear to me what the point of a distinction is supposed to be, because even if there were a gap in time or 2 stages, the whole way this arrangement is supposed to work is that reallocation is something in the discretion of GSAM, that GSAM holds a special power capital and has power to reallocate it, and whether that is something that takes place over a period of time or in one moment, it's still the case that it's the exercise of that discretion that causes special capital to stop belonging to GSAM and start belonging to the individual member. And that seems to me to follow from the idea that this is a discretion in the hands of GSAM. So I'm not sure where it is supposed to, how it's supposed to help.
Well, I think the case against you is the pointing to the case law we were taken to this morning, the right, creation of the right, or there's reference to the right, the exercise of the discretion creating the source, which Mr. Prosser says means a right.
If that means there has to be an intermediate stage, you exercise your discretion, you have a right, and the right then produces the income, I don't think that does seem to be what the case is saying. I'll go on to that.
Okay.
If it simply means that you end up with legal rights after the discretion has been exercised, that would be true here whether the legal rights arise immediately or later. There is still a transfer of special capital from GSAM to the individual, and that transfer is a result of the decision by GSAM to exercise its powers. Whether or not there is a gap of time in which, before somebody unspecified decides to register, to sort of record the special capital has actually been allocated.
Well, I was thinking, again, you'll come on to it, I was thinking the example, let's say trustees deciding to exercise their discretion to pay income for the benefit of some children. They can either do a nice trustee resolution and then instruct someone else to go pay, or they can these days sit round the electronic banking app and press the button.
But I would be surprised if it made a difference.
Well, that's I suppose that's the critical question, and Mr. Prosser is relying on statements in the cases that he says, I think, indicates that it does.
I think I would say that even if it did make a difference, once you have been reallocated special capital here, you clearly have rights. You have rights in terms of you're now beneficially entitled to the income from it, and you can call for it. And that reallocation follows from the decision to reallocate, whether or not it is the same thing as the decision to reallocate.
But if it's right that special capital is essentially the property of the partner to whom it is allocated at the time, how is that different to the headmaster, ex-headmaster? Because once he's paid, obviously he's got the money.
I say that it's different because the real issue of the ex-headmaster is that the courts decided that that was an example of a series of gifts, and that whatever is going on here, it is not right to describe it as a series of gifts. And I'll take you through that when I get on to
Thank you.
Ballot. But it would certainly seem surprising, I would say, if the difference for tax purposes rested on whether there had been a line in this deed saying, upon a decision by GSAM, reallocation shall take place. Given that we know that what is supposed to happen and does happen is that reallocation does take place. I mean, that's what this is designed to do, is that they take their decision and then there is a reallocation. I mean, the argument...
So basically you say it's entirely artificial.
I do say that. I say it's an artificial way to read this document, to say that there is this distinction. And that decision to reallocate exercised by the person who is given the power to make that decision has no consequences seems to me a very surprising way to read this document. I'm not at all. I don't think it can be distinguished from Bluecrest. You were taken to paragraph 75 in the Upper Tribunal of Bluecrest, which was said to imply that the exercise of discretion had created rights. I don't think I don't think that's there in that decision or in the Court of Appeal that the arrangements were different to that extent. Go to the Court of Appeal in Bluecrest at volume 5, tab 38 of the authorities. You'll see what they set out about the reallocation clause in that case. That's page 1155.
Which paragraph?
Paragraph 32.
Yep.
Yes.
And
It's quite similar wording.
it is quite similar
Yes.
wording. I don't think there's a basis, at least not one in the decisions, to suggest that there was some additional right created in Bluecrest that isn't being created here in between deciding to reallocate and beneficially receiving the special capital. I mean, the argument on this, I think, is made most clearly in the appellant's supplementary skeleton at paragraph 23. So this is core bundle.
Core
Core
3.
bundle, tab 3, starting at paragraph 22 and 51. And what I do need to say about this is that we don't agree that this distinction between deciding to allocate and allocating was argued at first instance. It was definitely argued in the Upper Tribunal. In particular, the distinction they set out clearly in 22, that there was no obligation, whether upon the exercise of discretion or at all.
Sorry, where are you reading from?
I'm reading from paragraph 22 in their supplementary skeleton, which is page 51 of the core.
Yeah.
Because we would say that the argument that there were no rights even after the decision is something which is first made in the Upper Tribunal. And this matters because of the submissions that have at least been made in writing in relation to Mr. Badsey. Because we say, had that been argued at first instance, this matter could have been explored in a way it cannot now be explored. The reference I would give you for what I say in the case was there is if you go to supplementary bundle, tab 18, page 277.
Tab 18,
277, paragraph 55.
And this is the appellant's skeleton
First
before the first tier.
Yeah. They've got a skeleton and they've got a reply skeleton first, yeah. And I'd say paragraph 55 does not flag up that they're suggesting, that they certainly are arguing, they're consistently arguing that the reallocation is voluntary. But the idea that there is no right after the decision has been taken, I think, is not present there. And though they say that this is made in the supplementary skeleton, and they refer to the reply skeleton, and they refer to paragraphs 25 to 32. Those are at page 295 of the supplementary bundle.
And those were paragraphs.
25 to 32.
Thank you.
And I understand those to be still making the argument that there is no obligation on GSAM to make payments, but not identifying this distinction that there is no obligation to make payments even after you have resolved to make them.
There's no obligation.
That's what's then dealt with in the first tier tribunal at paragraph 152. And then in the upper tribunal, page 317 of the supplementary bundle, they absolutely and clearly make this argument. It's in paragraph 62.
Give me the page number again.
Page 317.
Sorry, you're in the upper tribunal.
Sorry, the upper tribunal skeleton, so supplementary bundle, page 317. But it's made at that stage purely as a matter of construction, which is a matter of law. I mean, we don't suggest they can't make that argument. But what we do say they can't do is rely on what might or might not have happened in Mr. Badzian to change, which the documents, Mr. Prosser didn't take you through them in opening, but they are referred to in his supplementary skeleton, as to whether the changing the changing resolutions of GSAM tell you something about the construal of 11.9.
Okay, do we just not have factual findings?
Yes, I mean, I don't think we do have factual findings. We absolutely have factual findings that he lost his expected awards. But in terms of, it's also, but in terms of what happened and when, in kind of internally, when special capital was acquired, when that month period started running, when the reallocation took place, we don't have findings that would say GSAM made a reallocation and then made a different reallocation. So I don't think there's anything in that material that can be used to construe 11.9, which I say has to be construed simply as part of the document. Yes. Nor do we have something that clearly says it made a decision to reallocate and then made another decision, because as those resolutions, as I showed you with the resolution I took you to, that resolution is before they're able to take a decision to reallocate, because by definition they haven't even gone through the special capital, so they have the month hasn't started running. So I was then going to move on to the Braganza argument.
Mm-hmm.
So you've seen that 11.9c gives GSAM a discretion to reallocate special capital. And so the question is this an entirely free choice on their part, as if they're a private individual dealing with their private property? And we say no. This is a commercial discretion conferred under the LLP deed and which has to be used for its proper purposes. I've taken you through 11.9. The GSAM is treated differently from other members. There are there are provisions that apply specifically to GSAM. It's defined as a retention member, and it's only given allocations under the clause I took you to, for which are defined by reference to the retention amount.
So that's a reference back to 10.3, isn't it?
To 10.3.
Yeah. So you say in 10.3 and 11 it's treated differently.
It's treated differently. And even things like Schedule 6 and 7, there aren't draft recommendations to other members. It is an agreed part of its membership of the LLP that the cap, as it was abbreviated, is that it will run the cap. So Braganza is Authorities Bundle 3, tab 31. So, on page 592 of the bundle, you have the passage at paragraph 18. So, Braganza was a case about essentially a death in service payment, and it was whether the employer of Mr. Braganza needed to act reasonably when determining whether or not he died by suicide. But it summarises a lot of the principles on implying these discretions into commercial contracts. So if I ask you to read paragraph 18. And then paragraph 57, which is on page 601.
'57.
57.
Thank you. That's the Orkala. Yeah.
Yes.
Mm-hmm.
If I could then take you to Hawkalak. So this is a case about an employment a banker was suing his former employer, and one of the questions was, could he get damages for a discretionary bonus. It's tab 27, page 336 of the main volume.
Yes.
And if I'd ask you to look at paragraph 11, which is on page 342.
Mm-hmm.
So that, in this case, it was expressed as the sole discretion. Paragraph 30, which is on page 348. 37 on 350. Where they're referring to another example with absolute discretion. And then finally 46, which is on page 353. Well, it starts on 352. And I'd draw attention there to, this is a case about whether you can sue for damages, but it's looking in particular that this is part of the remuneration structure, which is the case here as well, and that you have to interpret apparently wide discretions so that they make sense as part of the remuneration structure that's being agreed. And that's what I'd take from that. That's an employment case. Reinhardt and Ondra we've put in because that's a case about status as a member of an LLP where similar principles are applied. I'll give you the references to paragraphs, but I won't take you to them, which is paragraphs 447 and 457, both for profit share and for expanding rights as a member of the LLP.
Which tab is that?
So Reinhardt and Ondra is 28.
Oh, thank you.
Yeah.
And that's in an LLP context.
That's in the LLP context. So I'd refer you to paragraphs 447 and 457 for the proposition that the same principles can apply between members of an LLP. If you want the page numbers, 496 for 447 and 498 for 457. So this isn't about employment, but it's about making the contract make sense, and the LLP agreement is a contract. And that if something is agreed as part of somebody's reward, and that's what they're working for, it's unlikely to be the case that it can be withheld arbitrarily. So if this was truly unfettered, it would imply that Mr. Bruder, as the director of GSAM, could, without any recourse, say, I'm going to give Mr. Shakin's award to Mr. Gerko. Or, I've met Mr. Shakin, I didn't like him, I'm not...
I didn't like him who wears red socks.
Yes, he wears red socks. That would be, and there would be no recourse. And the fact that the shareholder of GSAM has objects of benefiting the general business of it doesn't affect that. The LLP deed itself reinforces this. I mean, I took you to 10.3, where Mr. Gerko can only recommend a higher than 30% deferral for the purposes of incentivization. So this is an incentivization arrangement.
And that's there in 10.3D.
That's in 10.3D. So if the individual members were completely at the mercy of GSAM and the favour, essentially, of GSAM, whether they would receive anything or not, so it's more like presents they might be given, then this isn't an example of deferred remuneration at all. That would just be that they were reducing their remuneration and they might get presents from somebody else who's got a higher remuneration.
It would be reducing your remuneration and then putting yourself into a BELO context. A BELO in the sense of the ex-headmaster, hoping
yes.
hoping for crumbs from the table.
Yes, that would be. And I said that's not a natural way to look at the LLP deed or the provisions that govern the Capital Allocation Plan. This is how their remuneration deferral mechanism works. I've taken to you the references to sole and sole and absolute. In Bluecrest it was sole and absolute. The question of a Braganza discretion wasn't still in dispute before the Court of Appeal, but it was in dispute below. And in Bluecrest in the Upper Tribunal, if you go to, which is tab 37 of the Authorities Bundle, paragraph 38 on page 1090 refers to the sole and absolute discretion.
I'm sorry, I'm slightly behind. So 37 page.
Page 1090.
Thank you. And then I'm looking at paragraph
38.
Thank you. Sole and absolute discretion. Yeah.
And then paragraph 72 sub 3, which is at page 1107.
So subparagraph 3.
Yes. In terms of the arguments to be made that you shouldn't imply a Braganza discretion here, the relevant part of the appellant's skeleton is in the core at page 36, paragraph 60 to 63. And the suggestion that the trust which owns GSAM changes the way you construe this isn't mentioned there. I'd say that you would absolutely need a sort of further factual inquiry to suggest that the constraints on the shareholders of GSAM are something that should be used to construe this document. The shareholders of GSAM are not party to the LLP agreement. It's also the case that the only clause mentioned in that part of the skeleton is 11.9. So clauses 14 and 25, the whole agreement, entire agreement point, aren't referred to. Had they been referred to, we might have brought different authorities along. But I would point out the Upper Tribunal at 72. The argument was much wider than the Upper Tribunal of Braganza, where it quotes Mid-Essex on the basis that it's extremely hard to remove this limit on discretion.
is it? Sorry, I can't see that. 72.
Page 166 of the court.
Oh, the Upper Tribunal in this case?
Yes.
Oh, I misunderstood.
Yes, it's at the top of 166, and they're quoting from the Court of Appeal in Mid-Essex. Yeah. And the last 4 lines, that the essence of the implied term is that the relevant party will exercise its discretion in an arbitrary, capricious or irrational manner. Such terms are extremely difficult to exclude. And the reason for this is the one given in Hawkalak. This is about making the remuneration provisions make sense. And the overall interests governed, for example, by the objects of the purpose trust are not much of a protection for the individual members whose remuneration system this is.
Yes, because it doesn't help him if the irrational decision is to reallocate to another member.
No. I mean, it is not. It is not a radical thing to insert into the agreement. It's a rationality limit, but it has become, the courts have increasingly held, it is what you expect in one of these commercial agreements where the reward for somebody's work is being dealt with. Because as discretions have become more and more common, the idea that because your reward is discretionary, it is therefore arbitrary, is something the courts have not generally accepted. This is dealt with by the Upper Tribunal essentially at 63 to 70. I mean, I won't ask you to read through it, but that's where the Upper Tribunal deals with the argument. I would say 70 is correct and should be endorsed. 73 to 90 deal with a whole series of other challenges that were brought to the Braganza point below. And this then takes us to the Court of Appeal in Bluecrest at 123, which is page 1182 of the authorities bundle.
Paragraph.
123.
Thank you.
1183, sorry. And I would say that that passage is not distinguishable. I will now go on to explain why I say my little friend's arguments on source are not shouldn't be accepted. But in a way, I think that they fall away in light of that paragraph of Bluecrest, because there is no real distinction to be drawn between the arrangements in this case and the arrangements in that case. If I might move on to source.
Mm-hmm.
So, as I said, I'm going to deal with this first is the issue of whether a payment is voluntary, which is whether it's a gift, because there's a clear line of cases that say that voluntary payments are not income. This is not the same question as source, but in practice it frequently overlaps. And the reason something is said not to have a source often turn out to be the same reason. The courts seem to deal with them together. And it may be that there are cases where they are more distinct questions, and there are cases where I think they almost completely overlap. But first going to Ryan and Hoare, tab 10, page 118. So this is a case where the directors of a company received a 2% fee for guaranteeing the company's debts. And if you'd go to internal page, bundle page 125, which is 454 of the report. And just the lined passage, 2 kinds of emolument may be excluded. And that general observation, which essentially gratuitous payments are not income, is repeated 30 years later by the Court of Appeal in Scott and Ricketts, which is at tab 22. If you go to page 258, Lord Denning explains the facts really at 258C, and if you would read through there to 259 at F.
It's the same point again.
It's the same point, and that they are. If something's genuinely sort of a gift freely given, it's not income. If it's the price of an asset, even if it's the price of an asset that might not exist, which was the case there, price of a doubtful asset, it's a gain. But this point that gifts are not income, I think is crucial to a lot of these cases. You've been taken to Brocklesby and Merritt's, so I won't take you to the facts of that again. There's the passage at page 184 of the bundle.
Mm-hmm.
Sorry, will you just give me the page number again?
184.
Yeah.
Where are we looking?
The line passage before the break,
Mm-hmm.
I think you've probably read it already today. But the distinction being drawn here is between performing a voluntary service and then being given a gift, or providing a service and being paid for it. What it doesn't deal with is the question in the middle of performing a service on the basis that you expect to be paid, and the person dealing with it knows you expect to be paid, but you don't actually have a right to be paid. I'd say it's not saying that that falls onto one side of the line or the other, because the two options that were being looked at there were, was this a free gift in recognition of something that was done earlier, or was this an extremely advantageous agreement for services where you didn't need to do very much and you got paid a great deal? Now note, because it was suggested earlier, all these reference to voluntariness or about the kind of technical trust meaning of voluntariness, that's clearly not the sense that's being used here. Yeah, for no consideration. Okay. Well, I'm told that it wasn't just the trust sense, the things for no consideration. But I would say it is being used in the common sense. A perfectly voluntary payment would not be income, it would be a present.
I think Mr. Prosser also relied on the passage to the bottom of 184 where it says he had an enforceable right to get it.
Well, he did. Because what they decide is that he is being paid for a later service. Mm. It's just that service turned out to be nominal. I don't think this is authority of saying that if he had a doubtfully enforceable right, it would suddenly stop being payment and become a gift.
Well, you say Scott and Ricketts is authority to the contrary.
Well, Scott and Ricketts is an example of the contrary for capital payments, not for income. Because Scott and Ricketts, the fact that the payment was made to buy him out of a claim which he may well not have had was held to still mean you're still buying somebody out of an asset. So I think it does have it is analogous that they don't necessarily, the question is what are you paying this money for, rather than worrying too much about whether or not there are enforceable rights. But it's not the same question as whether or not you need a right to have income. So I would say Scott and Ricketts supports me by sort of general analogy, but not direct. What I say is important about this distinction, that a voluntary payment after someone has rendered services that they weren't expecting, they weren't entitled to on any level, is a gift and not income, is that is the way Stedford and Mellor is dealt with. So because that was a series of payments rather than a one-off payment, the outcome seemed more counterintuitive. But at every stage, Stedford and Mellor is dealt with on the basis that these are gifts. And this is clear from the first instance decision. So if you go to tab 12 at page 134, you then have, in the middle of that, you have the provision of the college statutes, college charter. And then at page 136, if I'd ask you to read the passage lined, in this case at the top, from Mr. Justice Rowlatt. And then at the bottom of that page, there's the passage just after the line, all you have an annuity being paid is unpaid every year, until the end of the page and the first line of the next page. That this is being described as similar to a private individual making gifts, and it's described as merely a contribution by some kind person every time. Now, because this is done by a board of trustees, and because it's a regular payment, that seems a slightly surprising way to describe it, but that is the way the courts are looking at it, that these are no more than private gifts. Then in the Court of Appeal, if you go to 151 of the bundle, that's the Crown's argument, and in the middle, further the grant of a pension was made under statute number 25. This is, at this stage, they're arguing that head on. They're on this point. They're saying, no, this isn't a gift. This is the exercise of your charitable powers, and that's rejected. You've been taken extensively to the Court of Appeal, so I won't take you too much of it again. I would just take you to Roma at 625.
Sorry, that must be the
162.
Sorry, 162. And so the point which both this court and the House of Lords deal with it in terms of that he's not one of the Setiki Trust, so it's not a discretion that's sort of targeted at him. The reason that matters is that means that as far as they're concerned, these are presents, a series of gifts, and they use the word gifts. That's the passage towards the bottom of the page. Merely the series of annual gifts made to him by the governing body of the college.
And also that it wasn't a payment in respect of his office or his previous service, directly anyway.
Yes. No. Had it been that, then that would have that would have been another reason why it would have been taxed. And I think you've been taken to the judgments in the House of Lords. I'd just direct you to what the Crown's concession in the House of Lords, which is page 166. That at this stage they've actually conceded that it's not connected with the office. That they say it would be the same if it was paid to anybody. But they've also conceded that there's no contract for it. So I just bear in mind those concessions when reading the House of Lords. but I think the House of Lords themselves do go back to this way that they describe it, this is at 168, as a mere donation. And that itself, that once again, I think stresses this point, that these questions about voluntariness, voluntary is used in these cases actually in the ordinary English sense. You don't pay income tax on presents, you don't pay income tax on donations and gifts. And that is the way this is distinguished from the trust cases by Lindis and Hortin. So tab 15, and they discuss this at page 175. And if you read a lined passage there.
Who's this a decision on?
Justice Finlay.
Thank you.
And so I'd say the question there is still, are these gifts, or are these, if they're gifts, they're not income. And now, in that case, and in Stedford and Bellow, the comparison is between a trustee or fiduciary, and they say, well, a trustee has discretion, but it's discretion which is to be exercised towards the Setiki Trust. But I say the distinction they're drawing here is whether it's fair to describe it as a voluntary gift or not. And in this case, even though this isn't a relationship of trust, and we aren't relying on any fiduciary duty, a payment under the cap arrangement is equally impossible to describe as a gift. Mr. Gerko was not receiving a series of enormous presents from GSAN. And that would be an unrealistic way to describe what was happening here. I was then going to move on to possessing a source. Obviously, look, Cunard is central to this case, but you have already been through it in Drummond, so I wasn't going to take you through them now. I was mostly going to comment on what is said about them in Sprite Beam and in Bucharest. But so, a lot of the cases about source do overlap with issues of voluntariness, and I say they're not entirely distinct, because one way of saying something doesn't have a taxable source is to say it's a gift. But it's been argued that source is a much more fixed requirement, and that you do need to have enforceable rights. And I say here the members absolutely do have enforceable rights, and they absolutely do, in the broad sense, own something. They have a set of rights under the LLP agreement. And in that sense, because of Braganza, they do have an enforceable right to this income. It's just not guaranteed. They have a right to have the discretion exercised properly, and that may produce income. But I also say that this is too rigid a way to approach source. you were taken to Bray and Best and the various references in the statute to possessions. We have to bear in mind that Bray and Best is a case about employment income. So when you talk about possessions, it has to be able to stretch. They clearly thought that was an apt way to talk about employment income. And so in a broad sense, you might say somebody possesses their employment. But it's not one of their possessions. They don't own it. And so a source might be something you own, but it can also be an activity, a status, a network of rights that gives rise to income. And it might give rise to income simply by the effluxion of time, such as a rental agreement or interest payments. Or you might need to do something, such as perform your role under the agreement. Or maybe somebody else has to do something, such as declare a dividend or exercise a discretion. And we say we are in that one, in that last case. They have, and that's what the first tier found. They have this set of rights which provides for a power in the hands of GSAN to confer income upon them. Once that power is exercised, that income has a source. I don't think Fumerhaven takes the case any further. It's obviously a High Court judgment, and it's actually about whether the point is reasonable. And I'd refer you for your note to paragraph 40 of Fumerhaven, which is where he actually says he's not deciding the point. But the fact that possession has to be used in quite a loose sense in all these cases, because it has to cover all these other kinds of income, remains. And so I'd say that Sprite Beam is perfectly orthodox.
So do you say that this concept of possession is a relevant concept?
I think it's a way of talking about source which has historically been used. It's more apt for some sources than others.
Because it doesn't naturally describe what happened in Sprite.
No. Though I would say it describes what happened in here and in Bluecrest a little bit better, because here they were parties to relevant agreements.
Okay, so the Revenue's position on this is just clarify for me, because what's being said against you is that possession is a necessary part of the test.
I think we would say that when 687 refers to income from any source, it is saying that the source of that income does not matter. This is not restricted. And that a source can be an activity or relationship. I mean, in Sprite Beam, I think it's particularly that they were a third party who couldn't enforce the payment that was to be made to them, but it was a payment that was to be made. And that means that you can give a coherent explanation of where this income has come from, which in Sprite Beam, though it is in that sense unusual as to quite how little connection they have to that which produces the income. It was still not really apt to say that this was, accidental or present to them. And the tribunals did find that they did have a sufficient relationship to that source for it to be aptly described as a source of their income.
So just going back to possession, you say that may be a useful label that helps.
Yes,
in some
but is appropriate. Is even in Bray and Best, it has to be stretched a bit to talk about it. I mean, to talk about somebody possessing their employment. Or professional vocation, which are also sources of income, and which might have no So obviously the passage in the tribunal is quite long, and you've seen it already. But I would say that 68 in Strike Beam,
Sorry, where will I find Spike Room?
579, paragraph 68, tab 30.
Thank you. Yes.
That where the person paying the income is acting under legal duties, even if they aren't legal duties that you yourself can enforce, that is still income with a source rather than something which has kind of just a windfall. Then I'd submit that that's perfectly orthodox and is not that far from stuff going back as far as Drummond. If you go to the very end of Drummond, in the House of Lords, Lord Renbury. So this is tab 7, page 82. Sorry, page 83. When Lord Renbury is talking about whether these are this is income from a foreign possession. And at the very end of 83, the test is not whether there is an absolute interest in the foreign possession, but whether there is such an interest that the party assessed derives income from it. And that if you have a network of rights or a set of relationships that are such that you derive income from this, that's an explanation for where your income is coming from. That is the source of your income. Strike Beam is a more extreme case than this because it was held that they didn't have any contractual right, whereas here everybody is party to the same contract. And we'd say, as the first year tribunal did, that there is an analogy to the way this is explained in Kerrison. Kerrison is tab 33, page, and I'd like to take you to paragraph 55. Kerrison was a case where it decided that there wasn't this thing as income. So this is 656 in the bundle, paragraph 55 of Kerrison. And they draw the analogy that this tribunal that the first tier accepted, that the situation of a shareholder who has no right to a dividend kind of in the abstract, but when the relevant decisions are taken, their rights produce a dividend, is analogous to the right way to look at something like Drummond and Collins or Cunard. This is then a point referred to again at 72 in the reasoning of the Upper Tribunal.
72 in our decision or this
72,
one?
659. Sorry?
In our case.
No,
No,
this-
in this case.
sorry, in the case you're looking at now, in Keres.
yes, I have to admit I was the FTT judge, so I'm not that I'm at all biased.
Well, the Upper Tribunal, I believe, endorsed it. So that this reading of what's going on, for example, in Cunard, makes sense. The beneficiaries under the trust have the right to be considered. It's an arrangement which they have rights under, but no right to income. But a discretion produces a right. Discretion then means they get income. And that's the natural way to read this, rather than what really matters in Cunard is that there are two stages. There's the discretion producing a right, and then you have the income. I mean, Falk earlier gave the question as to whether trustees who simply sat around and effected the transfer would be using their online banking. And I'd say the fact that the decision and the income happen at the same time can't change whether or not it's taxable income. And in light of that, I would say if you go to the first tier tribunal at paragraph 162 onwards, which is tab 16 of the core, to page 240. It's really actually 160 onwards, 160 to 172. The reasoning here makes perfect sense. And so the key objection, I think, which the appellants make is that the Cunard actually means you only have taxable income if the exercise of discretion creates a new right in your hands. We say that's not what Cunard is saying. It's also not how the Court of Appeal applies Cunard in Bluecrest. They are not focusing on this a new source arose reference, but that this is the kind of relationship where you need your rights under the will and the exercise of discretion to produce income. And that the meaning of a new source arising at that point is just that you obviously don't have any income until the discretion is exercised. On its own, being a beneficiary doesn't produce income. But it's not saying that you need some intermediate stage, a gap between the exercise of discretion and the income. So there is discretion creates right creates income. In a context, either under trust or under contract, where a discretion is conferred which may produce income for you, the income arises when discretion is exercised, and that is a perfectly appropriate source. It's finally the point on activity, because in this case the first tier did find that the activities were an appropriate source, and that in the alternative, and that was also upheld by the Upper Tribunal. The Upper Tribunal at 99 takes the view that a service provided quid pro quo for a reward can be a source whether or not you have an enforceable right to that reward. Of course, here we say there is absolutely a contractual reward provided for. It's not guaranteed, but it's part of the contract. It's how they work.
I can't remember, this point wasn't pursued in Bluecrest, was it?
Certainly not.
It's not discussed.
Not by the Court of Appeal.
It's not discussed in the Court of Appeal. I don't remember a separate argument.
I think it may have been, we may have run it at first instance, but I think from then on, Bluecrest proceeded entirely on discretion as source.
So as I understand, your primary argument is based on the contractual framework you've been discussing. Is that fair?
Is the exercise of...
Yes.
Yes, that's the primary. But I certainly read the tribunal's primary decision as being that that's the source, and its alternative is that the source is the activity.
And do you make any separate submissions on that?
On the activity?
Yes.
Yes, we would uphold that. We think the Upper Tribunal is right at 99 to say that you don't need a contractual right to be rewarded as long as there's quid pro quo understood. That you'll do the work and you will probably get the reward. But here, there is a contractual right, because everything done here is everybody's bound together by the contract, which is the LLP agreement. And the fact that that may not necessarily produce it, the income, doesn't mean that you're not, when you do receive it, it's not by virtue of a contract. I mean, given the way 11.9 C and D work, if you receive a reallocation, that is definitely by virtue of your rights under the LLP agreement, because a special capital only has any meaning within that contract. What's happening, as I took you to in Brockleby, is that if you do provide services and then somebody simply gives you a present in recognition, but you weren't providing the services to get that present, that's a gift. But here, even if the Braganza obligation didn't apply, it's quite clear that when you are made a reallocation, that's pursuant to the contract. I mean, we do say, Alloway and Phillips in the High Court, it's possible if you're awarded under a void contract, and the reason why that's right is that you're not actually asking the same question in the same way as in Scott and Ricketts. The question, is this the price of disposing of an asset, is not actually determined by whether or not you really do have a valuable asset. And are you being paid to write this book is not determined by whether or not you could sue for the payment. So I think the touchstone to all those cases is this in substance a gift, and in this case it's obviously not a gift. So those are my submissions. those are my submissions on 687.
Thank you. Mr. Prosser.
Yes. Just on that last point, the Alloway and Phillips point, it is important to emphasise that that was about whether there was property in the UK or not. It was not a case about activities which were carried on, as I say, abroad by a non-resident. So that case is totally irrelevant. Now, it seems to be common ground that the test of whether there's a source does not depend on whether the payment is voluntary or not. Mr. Chaco said that the questions may overlap, but they are separate questions. So I'm not going to spend time on discussing whether the payments in this case were voluntary, because that doesn't go to the heart of the issue, which is whether there was a source. I would submit that whether income has a source is necessarily separate from the question whether there is income itself. In Bray and Best, there was an employment benefit trust, and the trustees made payments to former employees. They received income, or something of an income nature, all right, but there was no source of that income in the year, because they were no longer employees. So these concepts of, have I received income, or something that would be taxable if all the other conditions are satisfied, and is there a source of that income, they're necessarily two separate things. Now, Lord Justice Henderson in Bluecrest distinguished between the income which was the special capital reallocated to the individuals on the one hand, and what he regarded as the source, which was the decision to reallocate to them. It couldn't be one and the same thing. It couldn't be that the reallocated income was the source of it, as it were, of itself. So Lord Justice Henderson clearly recognised that distinction between the income on the one hand and what its source is on the other, which is logically and perhaps temporally prior to the receipt of the income. Now, I therefore submit that there is a two-stage test, as it were, whether it's necessarily in timing or not, but it is a logical two-stage test that you have to identify the source of the income separately from identifying the income itself. And all right, there's this example of trustees sitting around and using their online app or whatever it is, but even then, okay, it may be a very short gap in time, but there isn't logically a decision being taken followed by a clicking of the mouse or whatever it may be. We won't get into how the brain works, but in any event, some people think that the clicking might occur first, but in any event, I would submit logically that there is a decision being taken followed by the act which gives rise to the payment. That is essential, and one can't do away with that, because if one does, one's saying you don't actually have to have a source at all. Now, if we apply that here, well, Mr. Chaco says actually there is no distinction in this case between the decision and the reallocation. Now, I don't understand that, because he, if I've understood him correctly, is saying that when GSAM decides to reallocate, that is actually the moment of the reallocation. There is nothing more to be done than for GSAM to decide. But if that's right, then how can the decision be a source of the income? The reallocation is the receipt of the income itself. That is the occasion on which the individual receives income in the form of special capital. If the decision to reallocate is itself the process of giving him that special capital, there is no separate source. So when Lord Justice Henderson said in Bluecrest that a source arose, that he could identify in the decision a source of income, he is, in my submission, recognising that there was something special about the decision that was separate and prior to the reallocation of the income itself. Special about it such that it could be properly regarded as a source of the income. So the reason I was focusing on the decision to reallocate was because I thought the Revenue's case was that was the source of the income, not being the occasion of the reallocation itself, but something prior to it. And in my submission, that is exactly right. That if one looks at the LLP deed, and I will ask you, if I may, just to look at that once more very briefly. Yeah. If we go to clause 11.9c,
C, yes.
11.9c, yes, on page 21, it makes the point that any member may, in its discretion, decide that all or any part of the interest of such member should be reallocated so that such other member will, following such reallocation, become, and so on. So that, and shall give notice of any such decision to the managing member. So that there clearly is a distinction there in terms of a decision to reallocate, followed by a reallocation, by whatever means that may be, some sort of legal step of assignment, perhaps. My understanding was that the revenue was saying, as in Bluecrest, the decision taken by, in this case, GSAM, is the source of the income. But that doesn't square with what Mr. Chacko is now saying, which is there is no difference between those steps. They're not two stages at all. They're a simple single stage. He also says that you can identify the source as being a network of rights, as he puts it. In other words, the whole series of rights conferred by the LLP deed. Again, that doesn't square with what Lord Justice Henderson was saying in Bluecrest, because of course, what he's saying is it's the decision of the corporate member in that case that was the source. It wasn't that there was a pre-existing source all along.
Well, isn't it the decision combined with the framework?
Oh, absolutely, yes. But it's a bit like a trust deed and the trustees exercising their discretion. It's the exercise of that discretion that, because of the terms of the trust deed, in my submission, give rise to the rights on the part of the beneficiary that Lord Green identified as the new source of income coming into existence. Of course, there's more to it than a decision. There's the rights that are created because of the trust deed as a result of the decision. But in relying on the network of rights, in my submission, Mr. Chacko is looking too far back. I mean, that is not consistent with what was said in Bluecrest about being the source, which is the decision. Not the fact that a discretion was exercisable under the terms of the LLP deed in that case. It was that the discretion had actually been exercised, and that was the time of the source coming into existence. So my submission is that if we're going to follow, as we must do, the reasoning in Bluecrest, one's got to identify a source separate from the income itself, which is at least logically prior to the income itself. What was identified in Bluecrest was the decision, and the question is, what's the significance of that decision? And Mr. Chacko said that Lord Justice Henderson wasn't focusing on a new source arising. I've written down what he said. But of course, that was the very passage from Cunard which Lord Justice Henderson emphasised. He emphasised that part of the sentence in Cunard, at that moment, a new source of income arose. And that was obviously vital to the question whether there was a source. And my submission is that the reason why a new source of income arose at that point was because, as Lord Green put it, Miss McFeeter's title to the income arose at that point. And so the question is, in this case, whether a right arose at the time when GSAM exercised its, took its decision. And if Mr. Chacko is right, that there is no distinction between the decision and the reallocation, then the answer is there is no source, because there is no distinction between the decision, which could be a source, and the receipt of the income itself. And then I think two very quick points. He didn't say anything about the Manduka case, My submission is, I've already responded to what Lady Justice Falk said about Mr. Justice Rose, as she then was decision in Manduka. My submission is she was saying you need to find a contract, in other words, a right to be paid. And then in terms of Braganza, I think one's got to bear in mind a certain amount of economic reality here, that we're looking at individuals who are working in the business, and if they don't get what they're expecting, then obviously they can stop working. So if you imagine for a moment that you had an LLP deed which did everything that was remotely required to exclude Braganza, which had a clause saying there shall be no Braganza duty, you can still have a working relationship between the parties where they work, and if someone says, I don't like the colour of your socks, I'm not going to give you your reward for this year, then you can see what's going to happen to the business.
But Mr. Prosser, it's not for this year. This is the deferred remuneration arrangement. So what you're hypothesising is that at the end of year 1, 2 or 3, someone says, I don't like the colour of your socks, even though the individual has worked, no doubt, on the understanding that part of the profits, which actually arose in year 1, are finally going to find their way to him in year
yes, fair enough,
2,
but
3 or 4.
fair enough, but there's also an element of reality to that too, isn't there? That one doesn't imagine there are legal rights on the one hand, but one doesn't imagine that anyone is going to be so ridiculous as to say, I'm not going to give it to you because of the colour of your socks or some irrational thing like that. They may be legally entitled to do that, but that's not the basis upon which people deal with each other, simply on the basis of what their legal relationship is. There is much more to it than that in terms of trust and understanding and so on and so forth, a relationship having built up and so on. So that my submission is simply that one shouldn't be analysing the LLP deed simply in terms of it can only be if you have certain rights that this can be made to work. That was Mr. Chaco's submission. And in my submission, that's pushing it too far.
And so, in effect, you're saying that the wording of the deed, sole discretion, etc., prevents there being a Braganza's implication, but in reality, the understanding will be that everybody will be good chaps.
No, well, when I say the understanding, okay, it's just an understanding which is leaving aside what the strict legal position is, that this works, this can be made to work nevertheless. And yes, in terms of the wording absolute discretion, I do rely on the fact that that is in contrast with other provisions that talk about a discretion which must be exercised in good faith. So the drafter has done what they can in my submission to say this discretion is indeed absolute. Absolute. There's a case where Lord Denning said, what does absolute discretion mean? It was, I think the White Book had said that the court had an absolute discretion. And he said, well, absolute discretion is like an absolute monarch. It's untrammelled. And the White Book was wrong because the court didn't have an absolute discretion. But that is the correct meaning of that expression. And the drafter has made it clear in my submission that that's what they mean in contrast with a discretion to be exercised in good faith. And okay, that's the legal position, but one can still go into a relationship of partners or whatever, knowing that we may have to resort to this LLP deed if things go wrong, but in the real world, we can still work together despite what the legal position is. So it shouldn't be looked at exclusively in terms of this can only work through legal spectacles. That's my submission. I've got no more submissions to make.
Thank you very much indeed. We're going to rise for a few moments. Please don't go away because we'll be coming back.
All rise, please.
What do you reckon?
Please remind the courtroom that the live stream is still running. Thank you. But it must be in the full library, right? I believe David's book. Purely personal. It's never purely personal.
Court rise at table.
Gentlemen, we will call upon you to deal with the second string to your bow tomorrow, but we would first of all like to say that you should take it as read that we have read very widely, and secondly, that we have read what you've said in your skeletons, and so I think you can take it very shortly and at, I hesitate to say some speed, but nevertheless, you can assume that we are very much aware of all of the issues there. And I think that this issue tomorrow can be dealt with on both sides and in reply by lunchtime. So if you would separate up the time between you and have that agreed so that we can get going at 10:30 and deal with it by the short adjournment.
Will do.
Thank you very much indeed.
Court rise at table.